So welcome to Jumbo IS and welcome to our lecture series called Prelims Powerplay. So as you all know that in this Prelims Powerplay lecture series, we cover the entire year's current affairs, important topics through this lecture series, okay? So all the important topics are divided into subjects and then we cover each and every subject one by one. We have covered economics. Currently we are on polity. So all the entire 1 year's important topics with respect to the subject of polity shall be covered through this lecture series. Now, if you have watched yesterday's lecture, you know this that we had started with the topic of justice, okay, judiciary basically, within polity, okay. Now, I had all the intention of finishing the topic of judiciary yesterday only, but some new topics came up, okay. There were some topics, some current affairs that caught my eye, okay. And I feel that UPSC might ask questions, MCQs, in this year's prelims examination from those topics. Okay, so therefore, we are going to continue with the judiciary portion of Prelims Power Play lecture series on polity. Okay, so let's continue with judiciary. Clear? So let's start without further delay. Okay, so within judiciary, today we will cover these 4 topics. Number 1 in this list is how Supreme Court hears cases. What is the proper procedure of hearing cases? Okay, what is the role of Chief Justice of India? What is the administrative machinery behind Supreme Court? Okay, we need to know that because they can frame an MCQ out of that. So we'll cover this topic. Then we'll talk about origins of Lady Justice. You must have seen the statue of Lady Justice, okay? A blindfolded woman holding a sword and a balance in her hand, right? That is a symbol of justice, Lady Justice. So recently, Supreme Court made some changes in that. Okay, so we'll talk about this, origins of Lady Justice. Then there was this controversy with respect to High Court judges' appointment, especially with respect to Himachal Pradesh High Court. There was some controversy. So that brought into question judges' appointment in High Court. So we'll talk about this. And in the end, we'll talk about this designation that some advocates, some lawyers have in the Supreme Court, and that designation is senior advocate. So who are senior advocates? We'll talk about this. Okay. So without further delay, without further ado, let's start with topic number 1, which is how Supreme Court hears cases. Okay. Now in this topic, we will talk about the procedure of how cases are admitted to the Supreme Court, how cases are listed in the Supreme Court, what is the role of CJI, and what are these other officers in the Supreme Court, apart from judges and lawyers. Well, Supreme Court is not about judges and lawyers alone. There is a whole administrative machinery. There is a whole host of officers who make Supreme Court work. Okay, so what is their role? We will talk about each and everything one by one. Now, the reason why this topic was in the news was because of a very simple reason. Supreme Court basically admitted a special leave petition. And in that admission of special leave petition, well, the entire process of Supreme Court got into the news. Okay, that's why we are discussing it. We will talk about what special leave petition is also, but majorly our focus will be on how this entire administrative machinery of Supreme Court works. Okay, so let's start. First of all, we'll talk about the role of CJI, Chief Justice of India. Chief Justice of India is not the highest judge in the Supreme Court. He's also given one task, and that task is called Master of Roster. Now, what do you mean by Master of Roster? Okay, well, CJI will decide what is the proper procedure of admitting cases, and it is CJI's job to basically create rules how cases are admitted and how cases are listed. In fact, the timetable of the Supreme Court, on which day which case will be listed, on Tuesday which case will be listed, well, it comes under the overall control of CJI. Okay, this is what we mean by Master of Roster. Then, which case will go to which judge or which bench of judges, that is also decided by CJI. So this case will go to this particular judge, this case will go to this particular judge, this case will go to a 3-judge bench, this case will go to a 5-judge bench. That is decided by CJI. Plus, what will be the strength of these benches? Okay, whether it will be a 3-judge bench, whether it will be a 5-judge bench, that decision is also taken by Chief Justice of India. So Chief Justice of India is not only the highest, most senior most judge in the Supreme Court, he is also the administrative head of the Supreme Court. And by that logic, okay, or extending this, well, it makes Chief Justice of India the master of roster. So as a master of roster, you need to understand this phrase. As a master of roster, Supreme Court Chief Justice of India will decide how cases will be listed, which case will go to which bench of judges, what will be the strength of benches. Okay, this decision, the final call over this will be taken by the Supreme Court, not Supreme Court, Chief Justice of India in Supreme Court. Okay, so the entire machinery of Supreme Court works under Chief Justice of India. Chief Justice of India, remember this, I'm repeating this line. Chief Justice of India is not the senior most judge, he is also the administrative head of the Supreme Court. Hence, his role is master of roster. Now, the reason why this news was basically, it made headlines, was because of a particular kind of case that gets admitted to the Supreme Court, and that is known as special leave petition, also known as SLP. Okay, so what is this special leave petition? Okay, now special leave petition is also mentioned in our constitution under Article 136, and it basically gives a sort of superpower to the Supreme Court. Okay, well, there is one superpower of the Supreme Court which we have talked about, Article 142. To do complete justice in India, Supreme Court can assume the role of executive, legislature, anything. But this Article 136 gives Supreme Court the power to admit any appeal against any court or tribunal in India. Okay, so if you are not happy with the judgment of a high court or of a tribunal, income tax tribunal, you can appeal against that decision. Okay, well, you can lawfully appeal against that decision, or you can appeal against that decision in the Supreme Court using special leave petition. Now, how is special leave petition special? Okay, I'll give you an example. Look, in our country, if there is a river water dispute between two states, okay, then that river water dispute is decided by a tribunal. And it is clear in our constitution as well as in the law that whatever decision will be given by that tribunal, well, that would be final. No appeal against that decision lies anywhere. So the decision of river disputes, well, will be taken by River Dispute Tribunal, and their decision shall be final. Okay? But if a particular state is not happy with the decision of a tribunal, well, they can still appeal in the Supreme Court using special leave petition. Okay, so it is a special power. If there is no appeal mechanism in the Supreme Court, then still you can appeal against any decision of any court or tribunal using special leave petition. Now, special leave petition is a special power of appeal. Okay, therefore, Supreme Court is very cautious using it. So if you are appealing against any decision of any tribunal or high court, okay, and you are willing to use SLP, well, Supreme Court won't admit that SLP. First, Supreme Court will hear a case, whether they should admit this petition or not. That case generally on average lasts for 2-3 minutes, okay. Supreme Court will decide whether they will admit your appeal or not. If Supreme Court is satisfied that it should, then Supreme Court will say that your petition under SLP is admitted. Okay, so this is the power of Article 136. Clear? Now let's quickly talk about how cases in the Supreme Court are basically admitted. Okay, or what is the journey of a case? Or basically, I would give you a peek into the administrative machinery of Supreme Court. Okay, this is important because, well, a question might be asked. So if you are to file a case in Supreme Court, then you will first contact an advocate. Okay, that advocate is called Advocate on record. Okay, AOR. You cannot ask any random advocate to fight your case in Supreme Court. Only advocates on record are allowed to fight cases in the Supreme Court. Okay, you have to pass. If you're a lawyer, you have to pass a special exam to be registered as advocate on record. Okay, then this advocate on record will basically submit the petition. Okay, submit the entire case with all the documents to a special filing platform. Okay, you can file your case online also, you can file on a special window also, that is known as section 1B in Supreme Court, but that is not important. Okay, you will file your documents, then a special officer will basically scrutinize your documents, whether your documents are filed in a proper format, the applications are all right, signatures are all right, whether the advocate is actually advocate on record or he's some person who is like trying to disguise himself as an advocate on record. Everything would be first scrutinized, and then after scrutiny that case would be admitted, and then it will be listed. When it will be listed, a special date shall be allocated to it, and on that date hearing would take place. In that listing, the bench would also be mentioned that this case is going to this particular bench. Clear? Now remember that the entire Supreme Court, this is important, okay, the entire Supreme Court has basically two wings. One is basically, well, it's judges and, let me explain it in a better way. Well, there are judges and lawyers, then there is this administrative wing also. Okay, that takes care of all the entire administration of Supreme Court. Okay, that is known as the registry. So registry is the administrative branch of Supreme Court. Okay, registry has two wings, administrative, okay, and judicial. So it has two wings, registry, administrative and judicial, and both these wings have many divisions. Okay, each division is headed by a registrar. Okay, and the entire head of entire department of registry, okay, not divisions, the entire head of registry is called Secretary General. Secretary General is the highest administrative officer of the Supreme Court. He is answerable only to Chief Justice of India. Just remember this part. Okay, so the administrative work is taken care of by the registry. Registry has two wings, administrative and judicial. Each wing has many divisions. Each division is headed by a registrar, and the entire registry is headed by Secretary General, who is only answerable to Chief Justice of India. Clear? That's it. That's all you need to know as far as this topic is concerned. And now let's move on to second topic, which is origin of Lady Justice. Now the thing is, you all must have seen that this statue of Lady Justice in movies, in actual courts also, courtrooms also. So it is a basically lady which is blindfolded. She's holding a balance in one hand and a sword in the other. Okay, and she is referred to as Lady Justice. Okay. Now this statue or this legacy of having Lady Justice is a colonial legacy. Okay, we basically borrowed it from the British. The British borrowed it from Greeks and Romans. Okay, so we basically got this statue of Lady Justice from Europeans. Now recently, Supreme Court of India Indianized that Lady Justice. Okay, so that Lady Justice was wearing a gown, a sword in one hand, a balance in other, and she was blindfolded. Well, a new statue was unveiled in Supreme Court in which instead of a gown, the lady is wearing a sari. Instead of a sword, she's holding the copy of a constitution, of our constitution, and she's holding a balance, okay, that balance, and she's not blindfolded. These changes were made to decolonize India, to decolonize each and every institution of India. It's our justice system, so we will have our own cultural symbols and our own statues. Now, this new statue was unveiled in the Supreme Court. Okay, so let's take a look at that. Okay, and let's gather a few little information with respect to that. Okay, then we'll move forward. Not much information is there. Okay, so this is the original statue of Lady Justice. This is the new statue. As you can see, she's wearing a gown, she's wearing a sari. There is a sword, there is a copy of Constitution. Balance is similar. She is blindfolded, she is not. Okay, the idea of blindfolding Lady Justice was that justice or proper justice is that in which no discrimination is done. No caste, creed, color is seen. Justice is done properly. Okay, there is no discrimination. That is why Lady Justice is blindfolded. She doesn't see class, caste, anything. She does proper justice. But while unveiling the statue of Indian Lady Justice, okay, well, former Chief Justice of Supreme Court, he said that our Lady Justice is not blind. Lady Justice sees everything and she treats everyone equally. Justice is not blind, justice sees everything. Okay, that is the idea. Clear? So this is the case. Okay, so they might ask you questions related to comparison between these two. Okay, what are the different features of Indian Lady Justice? Plus, as far as the origins of this Lady Justice is concerned, well, it has Greek origins. In Greek mythology, the goddess of justice is Themia. Okay, then this tradition continued even till the Romans. Okay, in Roman mythology, there is a goddess called Justitia, who is the goddess of justice. And this tradition carried on in Europe, okay, and Britishers, they came to India and we borrowed it from them, okay. The first statue of Lady Justice was established in Calcutta High Court. The first High Court of India is the Calcutta High Court that was established by the Britishers in 1862. So the first image of Lady Justice was established over here, Calcutta High Court. Clear? Remember, Calcutta High Court is the first High Court of India. Clear? And that would be all as far as this topic is concerned. It's a small topic. It just contained few points that you need to remember. Well, these are those points. I hope you remember them. Okay. Now let's move on to topic number 3, which is High Court judges appointment or appointment of High Court judges. Now, the reason why this topic was in the news was because there was some controversy with respect to the appointment of High Court judges of Himachal Pradesh High Court. Okay, there was some controversy. The collegium recommended some names, but some people raised objections over those names and they said that their candidature should be cancelled. So this brings into question the entire process of appointing High Court judges. Now, as you all know, that in India, whether they are Supreme Court judges or High Court judges, well, these judges of higher judiciary are appointed through a collegium system. Okay, though the Constitution doesn't mention anything about collegium system, but Supreme Court judges and High Court judges are appointed through a collegium system. Okay, when it comes to Supreme Court judges, well, Chief Justice of India and 4 senior most judges would constitute a collegium. They would scrutinize candidates and recommend the names of candidates for Supreme Court judgeship to the president, and the president has to approve it. Okay, that is the case with Supreme Court judges. So collegium will recommend the names and president has to approve those names, and as soon as president passes an order, these people are admitted as Supreme Court judges. But with respect to High Court, the system is collegium system, but it is a little complicated. Okay, so let's talk about this because only then you will understand this controversy also. Clear? So High Court judges appointment. So the thing is that the entire collegium system is nowhere mentioned in the Constitution. So how did the system come about? Okay, well, this system came about through Supreme Court Advocates on Record Association versus Union of India. Okay, this case was in 1993. It is also popularly known as the second judges case. The first judges case was in 1980s, 70s, late 1970s, which said that the recommendation given by Chief Justice of India is binding on the president, but that's a different matter. This is also known as second judges case, and in this case of 1993, collegium system was devised. Okay, so when it comes to the Supreme Court judges, the collegium system is very clear. Okay, Chief Justice of India plus 4 senior most judges. They will constitute a collegium, and whatever recommendations this collegium will give, those will be appointed as judges by the president. Okay, that is the case with Supreme Court judges. But when it comes to High Court, there was a lot of confusion. Okay, Supreme Court in second judges case said that, well, collegium will appoint High Court judges as well. But there was a little bit of confusion. Okay, therefore, President of India in 1998 asked the Supreme Court with a little bit of clarity how the collegium system will appoint High Court judges. Okay, so this presidential reference was well given to Supreme Court so that Supreme Court comes out with a detailed clarity on how High Court judges will be appointed. And this presidential reference is also known as third judges case. So in third judges case, Supreme Court properly gave some clarity with respect to High Court judges also. Okay, that was in 1998. And what clarity did Supreme Court give? So what is the procedure? Okay, so let's talk about that very quickly because it is not that detailed a topic. Okay, so in case of High Court, well, there will be a collegium that will have Chief Justice of India plus 2 senior most judges. Now this time there are 2, not 4. 2 senior most judges. Okay, this collegium will consult few people. They will consult other Supreme Court judges. Maybe there are some Supreme Court judges that came from that particular High Court. They can consult them. They will consult High Court also. Okay, Chief Justice of that High Court and other judges of that High Court. Okay, and they will also consult the governor of that state. Clear? After these consultations, well, a list of candidates would be given to the president and president will appoint those High Court judges. Remember, the appointing authority of High Court judges is also the president, not governor. Governor is just a consulting authority. Okay. Now, this is the process given by Supreme Court in second judges case. So how does this process play out? Okay. So what happens is, there is a proper detailed process. This process was given in third judges case. Okay. But a proper detailed, minute to minute details were given in Memorandum of Procedure 1998. So what happens is, well, Chief Justice of High Court plus 2 other High Court judges, okay, they form a High Court collegium, not Supreme Court, High Court collegium. Okay, they create a list of candidates. Okay, these list of candidates are given to, well, Chief Minister or Council of Ministers, okay, and the governor. The Council of Ministers or Minister for Law in that state, Chief Minister, forwards that recommendation to Union Law Ministry. Union Law Ministry checks the candidates, does a background check, checks everything, and forwards that list to the Supreme Court Collegium. Supreme Court Collegium consults Chief Justice of High Court, Governor, okay, and all these people, and then forwards this list to the President. And the President then has to appoint those judges, those people as judges, okay. Now, Supreme Court has made it clear that if anyone is not happy with this list of candidates, okay, they can file a case in Supreme Court that the list that you have forwarded to the President is not right. But you will say that it is not right only on 2 grounds. One, that not everyone was consulted. If anyone was missed, if governor was not consulted, then you can say that this list is bogus. This list did not consult governor. So if any one person is not consulted, you can cancel their candidature. Or if after thorough investigation you find out that some of these people are not qualified to become a judge of a high court, okay, the qualifications are given in Constitution of India. So on these two grounds, you can cancel the candidature of anyone in this list. Otherwise, whatever Supreme Court Collegium says after this entire process will go through. Make sense? That's all you need to know as far as High Court judges appointment is concerned. The detailed procedure would be given in your notes, so go through that, okay? And last, we'll talk about senior advocates designation, okay? Now, recently there was a bit of controversy in the Supreme Court because certain advocates in Supreme Court are designated as senior advocates, okay? Now, there is a proper process of designated certain advocates as senior advocates in Supreme Court. But there were a few challenges to that process. That is why this was in news. Now, those challenges are not important for us. What is important for us is who are these senior advocates and what is the process of appointing them. Clear? Make sense? Okay then. So, senior advocate designation. Now, the thing is, as per Advocates Act of 1961, there are two types of advocates, okay? Senior advocates, other advocates. Now, Supreme Court has said that senior advocates are those advocates, well, who have a lot of experience, lot of knowledge, who are well known in their field. Then only you will be designated as senior advocates. Now, if you are designated as senior advocates, well, then you will not appear in the court without a junior, okay? You will not directly take the brief from your client without a junior, okay? So you won't file the case, your junior will file the case. So there is a proper procedure, okay? If you're a senior advocate. But senior advocates demand a lot of or have a lot of respect. Any which way. So senior advocates and other advocates, okay? Now there is a proper process of designating any advocate as a senior advocate. Though the decision lies with Chief Justice of India and senior judges of the Supreme Court. So Chief Justice, it is completely in the hands of Chief Justice of India. So Chief Justice of India might consult some senior judges and designate a particular advocate who has applied for senior advocate designation as senior advocate. Okay. But in 2018, Supreme Court basically gave a list of guidelines also. That what will be the proper process. Okay. So in that list of guidelines, well, advocates would apply for senior advocate status. Okay. Now the Supreme Court has said that there is an age limit also. There is an age restriction. The advocate should be greater than 45 years of age. But this age can be relaxed by Chief Justice of India. Okay. Clear? So you apply for this senior advocate status, you must be 45 years of age. Then you are evaluated on a score of 100 marks. Based on your cases, based on your publications, legal publications, articles and whatnot. And if you score a minimum number of marks, you are given the status of senior advocate. Okay. Now, to oversee this entire process, that who else is 45 years of age or above, okay, verifying their age, verifying their documents, verifying their marks. For that, there is a proper committee. Committee on Designation of Senior Advocates. Okay. Now, this committee has Chief Justice of India, 2 Supreme Court judges, senior most, Attorney General of India, and 1 member from the Bar Council of Supreme Court. These people will oversee the entire process of appointment of senior advocates. That's all. Clear? That's all you need to know. Just remember that senior advocates have a statutory status as per Advocates Act of 1961, and there are proper guidelines given by the Supreme Court in 2018. and there is a proper committee whose members are as following. Clear? That's it. That would be all. And with that, we conclude today's session. And with that, we conclude the entire topic of judiciary. Now, you need not cover anything else apart from whatever we have discussed in judiciary. Okay, now is not the time to go through the entire topic of judiciary. Whatever we have discussed, that's all that you need to focus on and prepare for your prelims. Okay, make sure you revise from the notes provided to you on the Telegram channel. Without revision, you won't remember any of this. Okay, all right. On that note, I'll be signing off with the promise of seeing you again with another lecture on Prelims Powerplay Polity. Thank you, everyone.